Hello and welcome to our online event, Safeguarding Our Rights, the ECHR across devolved nations. This is organised jointly by the Human Rights Consortium Scotland, the Human Rights Consortium Northern Ireland, and the very newly convened Human Rights Consortium Cymru, which is hosted by WCVA in Wales. My name is Jen Ang. I'm a human rights lawyer and also a professor in practice at the Glasgow Open Justice Centre at the University of Glasgow School of Law, and I am delighted to welcome you today as chair of this timely event, which has been thoughtfully orchestrated to bring you insight, analysis, and hopefully some inspiration from some of the most brilliant people I know working in the UK on human rights in theory and practice today. As I've just mentioned, the session is timely, and I'll spare you the superlatives that you'll have been hearing: human rights at the forefront, never more needed, but a glance at any newspaper or news article, or indeed your online news feed, the radio and the television today, will tell you that human rights are indeed at the forefront of how we understand the world around us, and the public's understanding and engagement with human rights is actually probably at a global peak, thanks to decades of work by human rights defenders, teachers, artists, leaders, and lawyers who've helped us to know what that language means and what it can do. But it's also never more needed that the public understanding is clear and accurate, refined, made and remade. So this event was planned to commemorate the 75th anniversary of the opening for signature of the European Convention on Human Rights. The actual date of the 75th anniversary was the 4th of November. You'll be aware of this, but just a brief reminder, the ECHR was the first instrument in international law that crystallized and gave binding effect to the Universal Declaration of Human Rights. Specifically, what it did was to establish justiciable rights, or rights that can be upheld in courts when people ask for them. And it embodies the idea that all people are equal in dignity and worth and respect. What we've brought to you today is, as I said, an expert panel of theorists and also practitioners. And hopefully my colleague will put into the chat the agenda that has been circulated to you all. But on a relatively tight table, we're going to start by looking at why UK membership of the European Convention is important for all of us, led by a director of each of the human rights consortia in Scotland, Northern Ireland, and in Cymru. Following on from that, we're going to look at the use of the ECHR in action. And there we're going to look across children and young people's rights with Rachel Hogan from the Children's Law Centre in Northern Ireland. We will be looking at LGBT plus people's rights with Tim Hopkins, former director of the Equality Network here in Scotland, and across disabled people's rights with Rhiann Davies from Disability Wales. After that, we're going to turn to a quick fire interview between myself and my ex-colleague at Just Right Scotland, Andy Cyril, debunking the myths around the ECHR and addressing some of the current debates. Throughout today, we're going to have, in classic Human Rights Consortium style, the ability or an ask for you to interact with what we're doing by posing you questions to answer in the chat box. And where time permits, after each intervention, I'll pick up some of your thoughts or invite you to ask questions of the speakers, bearing in mind that we have 7 expert speakers. And as I said at the start, I could listen to each of them for an hour. But we'll do our best to pack all of that in, and hopefully you'll find it was a helpful, positive use of your time to join us today. So we run from now until 2 o'clock, and people who know me know that I am for a prompt finish. So I promise that we will come to some sort of conclusion at 2 o'clock, feeling better educated and hopefully inspired. So without further ado, I'm going to give you your question, and then I'm going to hand over to my colleagues, the directors of the consortia. The question is this: what are some of the ways that we should work together, or things we should or could do to protect the European Convention on Human Rights? So what are the ways we should work together, or things we should and could do to protect the ECHR? And whilst you're typing that into the chat box, I'm going to introduce Charlie McMillan, Director of the Human Rights Consortium Scotland, who opened today's meeting, Kevin Hanratty, Director of the Human Rights Consortium in Northern Ireland, and Ellie Wicks, Human Rights Policy Manager for the newly minted Human Rights Consortium Cymru. And my question for each of you, and you have 5 minutes, this is a bit like a kind of quiz show format, you have 5 minutes each Can you tell us about two of the ways in which the ECHR has been important for protecting rights of everyone in your nation or region? Over to you.
Absolutely. Thank you, Jen. Very quickly, I first of all wanted to say just a very brief word about the legacy, or rather the origin story of the ECHR. I think it's really, really important that we keep reminding everyone that this was born out of the Second World War and the absolute horrors that have been experienced probably in decades leading up to the Second World War and then the Second World War itself. I think it's essential we keep locating why the ECHR exists in that origin story, and also Scotland's role in terms of the writing of the ECHR and David Maxwell Fyfe's role in that writing was so profoundly important, and his story of the evictions and the Highland clearances that fed that for him, and that quest for justice and civil justice, so important. Because I actually am quite fed up with people saying to me, well, what do human rights do for me? Or what do human rights do for us? Because in Scotland, I think people are absolutely unaware of the power of human rights in their day-to-day lives. As a gay man who lives with his partner, I would not be living the life I have if it had not been for human rights and for the ECHR in particular. And I know Tim's going to speak about that in much more detail, but just a quick read through some of the rights that I'm aware of that the ECHR have ruled on that absolutely focus on some of the most vulnerable people in Scotland as well. Environmental rights. There have been over 300 environmental cases heard by the ECHR, safeguarding people against environmental hazards, and that's an ongoing piece. Scotland tries to be in the forefront of that work on the climate change and climate chaos, but that has been underpinned by legislation through the environmental rights part of the ECHR. Domestic violence, human trafficking, and childhood sexual abuse have all been areas that rulings have been made that have then led to changes in our legislative framework. Importantly, with the human trafficking, I was appalled to hear that before the ECHR ruling, we actually were in the situation of prosecuting those who had been trafficked in Scotland. And it was only after the ruling that changed and looked and focused at prosecuting the traffickers. Really big issue for me, mental health detention and deinstitutionalisation and the incapacity safeguards that the ECHR and the Council of Europe have brought. So critically important as the Labour Party and Labour government are currently challenging the Cheshire West ruling, which is anathema to us at the consortium as well. Safeguards put in place should not be challenged. ECHR has got very clear rulings on that and the safeguards that are needed by people who are detained in hospital settings. Decriminalising same-sex relationships I've mentioned already. You know it's a priority for me. That's what human rights does for me. Rights of Roma Gypsy people in terms of eviction and rules on stop and search. I'm only mentioning a few that I managed to gather together in a very short period of research. But the ECHR is absolutely central because it helps us have a voice for the voiceless, and it helps hold governments to account. And that's what it does in Scotland and has been doing in Scotland for the last 75 years. And it would be an absolute tragedy if that were to change. Thanks, Jen.
Thank you so much, Charlie. And I think what we'll have over the course of today is a long list, hopefully, of reasons why we should be grateful for the ECHR. I'm going to hand over to Kevin now.
Thanks, Jen, and thanks, Charlie. Hopefully you can hear me okay. So I'm going to, Charlie's given some very good specific examples. I'm going to give two broad examples. The convention has played such a significant role in Northern Ireland, both prior to our peace process and as part of the peace process. So the first example, prior to the peace process and the Human Rights Act being created, the convention had a significant, I suppose, legacy of protecting rights in Northern Ireland, specifically during the Troubles. And the Troubles, I suppose, a very sanitized way of referring to the intercommunal violence, intimidation, murder, general abuses of individuals and communities that we saw for over 30 years in Northern Ireland. And that was very often, I suppose, accompanied by a breakdown in the rule of law, and sometimes very often a failure to uphold basic human rights protections by public authorities. So the convention in particular helped challenge abuses of power by the state during that period. And there were a number of very high profile cases that were taken to Strasbourg to challenge those failings. And they helped set the bar, not just at a UK level, but at a Council of Europe level for how many of the convention rights could be interpreted and are still interpreted today. So you had cases like, particularly you had like the interstate case early on in the 70s, Ireland versus United Kingdom, actually it was 1978, which was an interstate case taken following internment that looked at how detainees were treated during internment and challenging those 5 techniques around hooding, things like stress positions, deprivation of food, water, the use of white noise, sleep deprivation, things like that. Those were all found at the Strasbourg court to be violations of Article 3. They were found to be inhumane and degrading treatment. And effectively, that then set a precedent for how that was interpreted or continues to be interpreted today. You had other cases like McCann and others that dealt with the fallout of the killing of IRA members in Gibraltar in 1988. That dealt with Article 2 and set the tone for how positive obligations around Article 2 should be interpreted moving forward. So again, precedent-setting judgments based on coming from Northern Ireland. You had the case of Brogan and others versus the UK in 1988, where applicants were held for over 6 days without access to judicial oversight. The judge found to be a violation of Article 5, right to liberty and security. So that was another case. And then finally, in the final case, the shoot to kill investigations, Kelly and others in the early 2000s, but based on the evidence prior to the Human Rights Acts and corporations, those were cases that helped specifically define those procedural duties around how Article 2 and 3 cases should be investigated, and those procedures are still used today. So those cases were all important, all pre-Human Rights Act, but all important because this exposed systemic abuses during internment or in treatment in detention. They forced the UK to amend laws and practices. They proved vitally the strength and importance of the Council of Europe, the Convention, the Human Rights Court in terms of delivering external accountability from outside of the UK. And really fundamentally, they laid that groundwork for incorporating the Convention later on into domestic law. So that's my first example. The second example is the peace process itself. And that's where the convention really came into its own for us. The agreement didn't just, I suppose, create those new political institutions at Stormont. They created and embedded, I suppose, a series of safeguards that would make sure those new institutions would function fairly and effectively. And primary among those was the idea of incorporating the convention into domestic law via the Human Rights Act. And that was one of the most significant confidence building measures. Because if you look back and think about what the agreement was asking us to do, it was asking 2 very different groups to share power in a government for the first time ever. We had all sorts of insecurities and concerns about how power would be distributed, whether power would be abused in the same way that it had been in the old Stormont regime. And the agreement recognized those concerns and really built in what it called those safeguards to ensure the institutions would work effectively. And that security that was created, I think, has been central to our sense of how the Assembly works. And in practical terms, it meant that, the Assembly and Executive were bound to act compatibly with the Convention. The ministers had to declare if draft legislation was in conformity with the Convention. Assembly legislation that wasn't could be struck down in the courts. There were access to remedies via the courts for individuals. And public authorities were under a duty to incorporate it into their day-to-day decision-making. And then finally, that also filtered down into really key human rights or public institutions and the best example of this is policing. There was policing reform took place in Northern Ireland. We have the PSNI, but the convention was filtered right throughout that. So officers trained in the convention rights, they had to take an oath related to the convention. There's oversight by a policing board that has a human rights advisor that reviews convention compliance, and even just public order policing and things like marching. Articles from the convention filter throughout the decision-making process in terms of dealing with that. So it's been active in day-to-day public authority decision-making. So it became embedded, I suppose, across that new system of governance at a key moment in time when I suppose hopes were high, but also so were anxiety in terms of what those new institutions would look like. And having access to the convention, I suppose, steadied the ship at a really important time. And I suppose now today is still in many ways helps keep it afloat. So I would dread to think what the institutions of what Northern Ireland would look like without access to the convention rights. And it continues to be a cornerstone of that peace process and all of those institutions. So I'll leave my initial reflections at that, Jen, and hand over to you.
Thank you so much, Kevin, for cantering us through multiple decades of history, what the European Convention and what human rights frameworks mean to Northern Ireland. That was very packed, and I'm sure that people will have follow-up questions. But I'm going to hand over to Ellie first to answer the same question: 2 ways in which the ECHR has been important for protecting the rights of everyone in Cymru. Over to you, Ellie.
Thank you. I'm going to go a little more generic because I knew my colleagues were going to go incredibly specific. So in terms of the impacts on Wales, one of the key things, and it relates a little to something that Kevin was saying, was that although human rights directly are not, equalities are at the heart of how the Government of Wales Act and devolution are written in Wales. And that in itself, due to the existence of the ECHR and the HRA, has been a way that we've been able to say in Wales, and the Welsh Government has been able to, and the Senedd have been able to say that human rights are absolutely something that need to be worked on in Wales, need to be taken into account in public decision making. So although it wasn't directly written as human rights, it was written as equalities at the heart. The existence of the ECHR itself and the HRA into domestic law has meant that human rights have been considered in Welsh Government, maybe not necessarily to the level we'd want them to be because of it not being written directly in the way that it is in Northern Ireland, but it still has been a key tool to be able to say these things are linked. We cannot work on one without the other. Without human rights, without everyone having their human rights in Wales, how do we actually give life to the equality obligations that are at the heart of how government in Wales is legally constituted and is supposed to run? So by its very existence, without that European Convention, human rights in Wales would not be being considered as part of government. And there are obviously discussions to what level they are being considered, but their consideration, full stop, I feel would not be there without that backup from the European Convention. The other area in Wales is that there's a lot that isn't devolved. And there's a lot more in Wales that isn't devolved than in Scotland. A lot of the rights that we would really want in Wales and we feel might be devolved, like the right to health, because our healthcare system is independent. But the funding that would be required for that is dependent on decisions being made at Westminster. So using the HRA and the European Convention and European Convention cases means that we can make those cases on non-devolved issues or where the levers are non-devolved and there's a limit to how far things can go in Wales. Those cases are being made to Westminster to say, actually, you have obligations too. This isn't just about Wales wanting to do things. We need the tools to do so. We need the resources to do so. And you have these obligations on a UK level as well, particularly as a state party. So this is something that we can use. And again, without the Human Rights Act and without the European Convention on Human Rights, we'd be talking into a vacuum where we wouldn't have the law behind us to be able to turn around and say, actually, this is something that needs to be done. Actually, look at these cases. Look at the things that are being said. Look at how your own law is structured. This is why we need what we need to be able to make this happen at a devolved level. So it is those two levels where it's central to the way that our own constitutional law is written in Wales, due to the links to equalities and non-discrimination and anti-discrimination, but also the levers to Westminster that wouldn't be there without the European Convention.
Thank you so much, Ellie. We've got sort of 5 to 8 minutes for some questions from the audience. If you have, please just type them into the chat and I'll pick them up. And while we're waiting for those questions, I had a kind of a mischievous one listening to the three of you speak. I mean, I think you highlighted very well multiple ways in which membership of the ECHR have impacted your practice and also the laws and practice of the nations we live and work in. So they involve being written into the core constitutional legislation of the areas where we work, but also just the impact of legal challenge and establishing minimum standards. I think we've seen cases like that in all of our countries, minimum standards where either there were no standards or where we were failing to meet them. And then this other piece, which Kevin mentioned as well, which is I guess, the positive progressive impact of the idea of human rights on some statutory authorities. I think you mentioned policing, Kevin. But I wanted to point out that some of these things could have been accomplished through other means, through other human rights legislation. So just to disentangle the ECHR from the idea of human rights in general, what does it mean as three people working together across devolved nations? What does our membership of the ECHR add in terms of work across nations or progressive work within the UK or indeed connections to Europe? So does it matter that some of these cases and some of this case law comes from the European experience or places that we don't originate? I know that's such a big question. I'm going to be like, you just have a couple minutes each, but I would love any response that you have to that. And I'll just let you unmute or go first rather than, whoever wants to go first, just into the breach. Kevin?
Yeah, just very quickly, I think I sort of partially mentioned this in my initial thoughts, but I think having that external oversight from a third country or a third body external to the UK was incredibly important and continues to be incredibly important, particularly when you take account of changed political dynamics and threats to democracy, to rights at a domestic level. There has to, I suppose, the concept of human rights as we've come to understand them, either a regional or an international level, is that there are duties that member states sign up to, and that therefore there has to be some sort of external enforcement. That we see limited versions of that at a UN level, but really the Council of Europe model is much more advanced in terms of being able to hold states to account. Yes, that's largely due to the political factors of states being embarrassed and not wanting to be seen to be out of step with other member states, but has been incredibly powerful force and momentum for binding states to be convention compliant. The other element was, and I suppose for us in the context of the Troubles, where there wasn't very much faith in the avenues for justice at a domestic level, it was really important to have that external body. The other element I'll say is that we have division in Northern Ireland, or we have sort of like people who align with nationalism and unionism. The HRA is unique, I suppose, in a UK context, and it is the one piece of on the convention, the one piece of legislation that applies universally across the UK, not just in devolution but across. And yet we still have some parties here arguing that to be properly be part of the union, we need to get rid of the HRA, which is a complete nonsense in many regards, because it is the one element of protection that we all share. So again, there's that sort of sort of united element behind the Human Rights Act that is really, really powerful for some people, and part of the reason why they signed up to the convention in the first place. So I'm sure Charlie and Ellie want to say more about it, so we'll stop talking at that. But those are just a couple of reflections on that point.
Yeah, for me, it's all about accountability. Where discrimination has become hardwired in all our systems, and we know that to be the case in all the work that I've done over the last 35 years in my social work career, I know how discrimination happens, and it's hardwired. We need that external consideration, that accountability. We need to be able to hold people to account, and without it, I think the lack of trust that Kevin mentioned is fundamental. a lack of trust in our own mechanisms to actually affect the change, because we know whether it's the post office, whether it's Hillsborough, wherever it might be, these things are still happening. These outrages are still happening, and we need that external pair of eyes on us and accountability. So that for me would be the big driver.
I would just add to that, in terms of justiciable rights, people talk about international rights. The UN treaties and conventions are absolutely vital, but they don't create direct justiciable rights in the same way that the European Convention does. So absolutely agree about we need something international, some oversight, something external that isn't domestic law. And the European Convention fills that gap that creates justiciable rights that the UN conventions do not create directly. They are not justiciable in the same way. And I think that's the real gap between that UN level and the domestic level that the European Convention fills, that without that, how would we have justiciable rights that aren't dependent on political interpretation at a UK level only, and then just having reports from a UN level? That justiciable intermediate level is absolutely vital to people really having their rights.
Thank you so much, Ellie. And I'm going to have to thank all of my panelists in this part of the session for joining me, as it were, on the sofa. So Charlie, Kevin, and Ellie, and for getting us kicked off with this question, why UK membership of the European Convention is important for all of us, but specifically thinking about our particular contexts as people who lead on this work in devolved authorities. And now that you've opened that up, what I'd like to do is invite the next panel in, and I'm going to ask for help with the pinning for our session on the ECHR in action. So first, Rachel Hogan from the Children's Law Centre, Northern Ireland. I'll wait for someone to help me pin Rachel. So Rachel is Rachel's from the Children's Law Centre in Northern Ireland, which was established in 1997 to protect the rights of all children in Northern Ireland. And you are the centre's SEND specialist legal advisor, leading work to give disabled children a voice and to challenge for protection of their rights. Your important work was recognised in July this year when you were awarded a LALI, or Legal Aid Lawyer of the Year award from LAPG. Congratulations, Rachel.
Thank you for mentioning that, Jen.
I hope that was fun.
It was great fun.
Yeah. Also welcoming to the sofa, as it were, Tim Hopkins, LGBT campaigner and formerly director for many years of the Equality Network Scotland, and such a fervent supporter that I understand Tim can still be found roundabouts the Equality Network. So for 26 years, you were there as a member of the Equality Network, including director for 13 years. Now retired, my notes say Tim has in one way or another been at the centre of all the significant steps achieved towards equality for LGBT plus people in Scotland and continues to campaign today. Welcome, Tim. And Rianne Davies, welcome, Rianne, from Disability Wales. You're Chief Executive of Disability Wales and have been in post since 2001, which shows considerable perseverance, I'd say, and a long-standing advocate of disability rights and equality. You're also a member of the Welsh Government's Disability Rights Task Force and chaired its Independent Living Social Care Working Group. You also chair the Disability Equality Forum Steering Group. You're Vice Chair of the Women's Equality Network Wales and trustee of WCVA, the Wales Council for Voluntary Action. So thank you to all three of you for joining us today. And this session, as I highlighted earlier, is about what using the ECHR in action looks like for campaigners. And all of you have worked across more than one equality sector, which I think is a really important thing to acknowledge, but also over a period of time in some cases, and maybe you have a perspective on what the ECHR has meant and means that will enrich our guests' understanding today. So my first question, and you have 5 minutes each to respond, is what are some of the ways that the ECHR has helped protect people's rights from your frontline perspective? And if it's okay, we'll maybe just go in the order that I introduced you. So starting with Rachel and then Tim and then Rianne. Is that all right? Okay.
Thank you, Jen. 5 minutes, I have to say all this. Okay, I'll try.
There are more questions.
Yeah, I think the first thing to really say about Northern Ireland is that equality law in Northern Ireland in general is very piecemeal and incoherent. So we really, really rely upon the ECHR to underpin our rights advocacy and the legal work that we do and the policy work. I've recently been doing a piece of work on reasonable adjustments for schools with another organisation, and we've been trying to translate an English version into a Northern Ireland specific version. And I can't tell you the difficulty we've had because we don't have a single piece of equality legislation, and we're having to dip in and out of multiple pieces of legislation that doesn't fit together well, particularly in the context of children. So I have to say I am very, very happy, speaking personally, to have the ECHR as a solid framework for me to stand on when I go to advocate for children's rights in particular. Children tend to have multiple equality characteristics when we're dealing with them in our legal practice, maybe on the basis of age, gender, disability, race, and it tends to be very complex. The cases I want to briefly talk about today are in education, which is my specialism, special education, respite, and the placement crisis that we have in Northern Ireland, where children with special educational needs are being the last children placed. I still have a couple of children in my books at the moment who are not in school, and school started on the 1st of September, and that's because of barriers and obstructions to their right to education. So it's Article 2 of the first protocol, and together with Article 14 on disability is going to be the focus of where we've been able to take action successfully using the ECHR rights. We have a case study that we use called Alana, and after I'm finished speaking, I'll put some links into the post and some of our works here in the chat so that you can see the sort of work that we are doing. But Alana is a child with multiple and complex and profound disabilities, including that she needs respiration and suction. She is visually impaired and physically disabled and intellectually disabled as well. During the COVID pandemic, and as we were coming out of the pandemic, we noticed that children with disabilities weren't accessing their right to education at the same rate as others. And the effect on Alana was that she wasn't at school for primary 1, which is our first year of compulsory education in Northern Ireland, and she wasn't in school for primary 2. By the time we got to our legal action, she was about to start primary 3. Meanwhile, her younger sister, who had no disabilities, had started primary 1 and was going out to school every day in her school uniform. And the reason that Alana had been blocked was because our education authority refused to transport her to school because they thought there was a risk that because she required respiration and suction, that she would infect the driver. Now, I'm pretty sure no driver was ever spoken to, and the risk assessment didn't look at what was the effect on Alana if she had no education. At the same time as she was at home, not getting any nurturing and personal developing educational experiences, mainstream children were packed into buses with no masks, and they were traveling to school every day, having great fun, good chat, singing, talking, shouting across to each other. And I'm sure particles were flying all over the bus, but nobody was stopping that from happening. To cut a very long story very short, I want to read you out the Human Rights Declaration that we agreed with the Education Authority in the High Court in Belfast. And I'll just read it out. And I have to say, a pin could have dropped in the court when this was being read out. It took a lot of work to get this recognition for this family as they sat in the courtroom. So it was declared that the respondent breached Section 6 of the Human Rights Act 1998 for a period of time which is specified insofar as there was interference with the applicant's rights under Article 2 of the first protocol to the European Convention on Human Rights in conjunction with Article 14 of the Convention, as there was interference with the applicant's access to education on the basis of her medical condition, and she was treated differently to other children in the state because of her disability. Now that shows rights in action right there. If I hadn't had that, I would not have had the strength of advocacy that I could put forward for that child. There were also breaches of domestic law as well. So I never see the ECHR sitting on its own. It's underpinning our domestic laws, such as they are. And it was extremely important for that child because the impact of her going to school was that she then received lots of sensory input. Obviously she couldn't see, but she could feel. There was bubbles, music, touching the sand, sensory feedback, company, peer interaction. And at home, it was observed that she was sleeping better. She was happier in herself. She was able to interact with her family. And for the first time, she learned to communicate using Makaton sign language. Now, her parents are not educators. They don't know anything about Makaton. They didn't know she could communicate. So it was on the one hand gut-wrenching that she had been disabled by the state's actions and omissions, and also very heartwarming that she was then able to pull back and learn those skills. And I think that's an important type of story for us to help people to understand why human rights are important and that human rights are for everybody, and that we have to have particular regard to children's rights because they are so vulnerable, and their protected status is layer upon layer of disadvantage. So that's one example that I wanted to give. And I briefly just want to mention one other client, and that is Aurelia. And I'm going to post a clip of Aurelia. Aurelia wasn't able to go to school for the first 4 months of term because she's a wheelchair user, pure and simple, and there was no bathroom facility for her to use. So obviously we used denial of education in tandem again with the right not to be discriminated against, also with all of our own domestic protections and entitlements, and we were able to resolve that case. But what we did then afterwards, we were able to bring Aurelia up to Stormont to our assembly to meet with members of our education committee. So we took those rights and used them in policy, and we'll use them in legislation as well. But you'll see, if you look at the clip, you'll see Aurelia up in Stormont talking directly to our MLAs here on the education committee. And I think we have to really try and pull together all these stories that we have about real people in their real life, who everybody knows. We are those people, and to make human rights real for our communities. So I know that I could keep speaking for another hour or two on this, but I'm going to pause it there, and thank you for the opportunity to do so.
Thank you so much, Rachel, for standing your ground, as any good lawyer does, and taking the platform that you have to tell us the very important lessons around what the Human Rights Act actually means for your clients. I just have a wee comment in the chat as well from someone who works in Scotland, saying the Craig Halbert Centre in Scotland has raised issues with the Scottish Government Minister that young children with life-limiting conditions are frequently denied access to early years education, with similar issues to the ones that you highlighted, Rachel. So also that the benefit of bringing people from across the devolved nations as the audience is to hear from each other, and also to understand that there are these links that we can build because of our common legislation. With that, though, I'm going to hand swiftly over to Tim from the Equality Network in order to share for us some of the ways in which you think the ECHR has helped to protect people's rights in your work and activism.
Okay, thank you very much for inviting me to come along. I should say I'm not a lawyer. I'm just somebody who's been campaigning now for 38 years, I think it is 38 and a half years, for LGBT equality in Scotland. So I've seen how the convention has been used to move forward, especially the law as it affects LGBT people, and to make some of the most important changes. So I just want to give 3 examples. The first one is one that Charlie's already mentioned, and it's the decriminalization of same-sex relationships. So going back to 1981, sex between men had just been decriminalized in Scotland. It was decriminalized in England and Wales in 1967, but it was still a criminal offence in all circumstances in Northern Ireland. So a gay activist in Northern Ireland, Jeff Dudgeon, took a case to the European Court and won in 1981 on grounds of Article 8, right to respect for his private and family life. And that led immediately to a change in the law in Northern Ireland, to bring Northern Ireland into line with the rest of the UK. But setting the age of consent for sex between men across the UK at 21, whereas it was 16 effectively for everybody else. And it needed 2 more cases during the 1990s, one in the early 90s, taken by 2 gay men who were aged 20. And that resulted in the age of consent being reduced from 21 to 18 in 1994. And then another case immediately after that, taken by a 17-year-old gay man to Europe. And that resulted eventually in 2000 in equalization of the age of consent and close to equality for sexual offences law. So that's my first example. My second example relates to trans people. Before 2004, a trans person in the UK could not get any legal recognition for their gender identity. And a trans woman called Christine Goodwin took a case to Europe. she wanted her gender identity recognized. She wanted to be recognized as a woman. And she also wanted to marry her partner, who was a man. Because the law regarded her as a man, and in those days there was no same-sex marriage, she couldn't marry. So she went to the European Court, and the court said that her rights were being breached both under Article 8 and also under Article 12, the right to marry. And that ruling, Goodwin versus the UK, led directly to the introduction of the Gender Recognition Act in 2004. So that's my second example. My third example is actually a case in the domestic courts after 2000, when the Human Rights Act came into effect. And this relates to the recognition of same-sex partnerships. So this case is called Guyden versus Golin Mendoza. Mr. Guyden was a gay man who'd lived with his partner for many years, and his partner was the tenant of the house that they shared together. And his partner died. Mr. Guyden wanted to stay in the house. And the tenancy agreement said that if somebody was living with the tenant as if they were husband and wife, then they could inherit the tenancy. But the landlord said, well, you aren't living together as husband and wife because you're both men. This was back in the very early 2000s. So Mr. Guyden took the landlord to court, and I think he lost at first instance, but it went to the Court of Appeal in 2002. And the court decided that, taking into account that the Human Rights Act was now in effect, that what had happened to him was a breach of his Article 8 rights combined with Article 14, the prohibition of discrimination. And that was later upheld by the House of Lords. That result was one of the main factors that led to the Civil Partnership Act being introduced in 2004. So you can see three examples there of the use of the convention, either at the European Court or here in domestic courts, that led directly to three crucial changes in the law for LGBT people. And I think that's my 5 minutes up, so I'll stop there.
Thank you, Tim, very much again for that really educative canter within your 5-minute limit through some of the key cases from your perspective where the European Convention on Human Rights has made a real difference to LGBT plus rights. I also want to say, because of your little disclaimer at the start about not being a lawyer, I think working alongside activists like yourself and your team is a very good example of why the law is too important to be left to lawyers. I think that the law is something that we make and remake, and actually without like human demand and imagination, the law doesn't evolve. So I always love to listen to people who've lived through these cases and can kind of tell us as it happened, what it looked like, what it meant. So thank you for sharing a bit of that with us today. And now I'm going to hand over to Rhian Davies from Disability Wales. Over to you, Rhian.
Good afternoon, everyone. Really delighted to be here today. Disability Wales, we're a national membership body of disabled people's organisations, and our vision is striving for the rights of all disabled people, and our vision is for an inclusive, equitable and barrier-free society. So as an organisation, we are more of a campaigning, influencing organisation, as opposed to one that is, kind of takes up cases. So we use things like the ECHR and also the UN Convention on the Rights of Disabled People as a kind of a campaigning tool and an enabling and empowering tool. But in terms of how the ECHR has played a really important role for many disabled people in terms of securing direct rights and protections. One is around disabled people who find themselves in custody or in prison, or maybe detained under the Mental Health Act. We know disproportionately people with mental health conditions or people with learning disabilities are often, in custody or in prison, for example. And the European Convention has, helped to uphold people's rights in terms of freedom from torture, inhuman or degrading treatment or punishment. For example, making sure that there's appropriate conditions suitable for people's need, people have adequate medical treatment, for example. Also in terms of people who are detained under the Mental Health Act, there's access to independent mental health advocates, people who can offer patients, advice about their rights, and how the mental health legislation applies to them. Also, of course, for people who are undergoing treatment, health treatment, the convention is vital in terms of people's right to a private and family life, and in particular physical integrity. So, for example, it's led to stricter rules regarding consent for administering drugs to disabled children or adults who've been deemed to lack capacity. So these have really been vital protections, to disabled people, and I think many, in terms of making the case for human rights, I think it's really important to highlight these, because for many people, either as individuals or have family members who find themselves in extreme situations, often where the state has has a lot of control over their lives, and those access to those rights are really important to those individuals and to those families. The other thing I wanted to pick up on, which is what Ellie talked about earlier on, is the role of rights in Wales, and how under the Government of Wales Act, the Welsh ministers are prohibited from exercising their functions in any way incompatible with the ECHR, as well as other UK international obligations. And over the years, the Welsh Government has and the Senate has passed legislation which has referred to or paid due regard to human rights, and in particular various UN treaties, whether that's the rights of the child, the UN principles on older persons, and also the UN Convention on the Rights of Disabled People. And that includes in legislation such as the Social Services and Wellbeing Wales Act, and the Additional Learning Needs and Educational Tribunals Wales Act. I mean, I think we feel that there is a lot further where the Welsh Government could go. For many years, DW, alongside other organisations in Wales, have been calling for full incorporation of human rights in Welsh law, and also, the incorporation of particular treaties. This current Welsh Government did commit to incorporating both the UNCRDP and CEDAW in Wales. Progress is being made towards that, but it's very, a few months away from the elections in Wales next year. It's looking unlikely that that will be achieved. So our forthcoming manifesto, which we're publishing soon, no spoilers, will include a renewed call for that incorporation. But as I mentioned, what we have done as an organisation is use rights as a sort of a campaigning tool. So we've produced resources, for example, like our Know Your Rights pack, which looks at how disabled people can exercise their rights, and include around human rights as well as rights under Welsh legislation. So it's always really heartwarming to us when we hear stories of when, for example, individual disabled people have used those resources to, for example, challenge decisions around assessment for social care and sort of provision they get, or challenge their local authority around policies around, say, blue badge provision in local town centres, or imposing charges or that sort of thing. So I think that's another really vital part. It's about how human rights empowers people and makes people feel, enables people to feel, actually, I do have a voice here, I do have rights, and even without going to court, I know I can exercise those rights and ensure equality in our lives. So, diolch yn fawr, thank you.
Thank you so much, Rhian, for sharing that. And I actually, when I listen back to what you've said and I put it alongside what Rachel and Tim have said, I see something which I think is brilliant and kind of beautiful, but I could just be quite a legal geek. I don't know. But it's how across decades, but also across geographies, each of you are speaking about the same articles of the European Convention. So Article 3, which is the right to the right against cruel, inhuman, degrading treatment, Article 8, the right to privacy, Article 14, the prohibition on discrimination. You're speaking about how each of these have been used in order to secure rights or protect people from harm or to achieve equality in very different contexts. And I think it is something to wonder that this legal framework has been able to be used in such diverse ways, and actually is now increasingly, because human rights defenders have been doing this work, understood a little bit by the public and statutory authorities to be read consistently in those ways. But that is going to lead to my provocation, which is this. So my next question for you, and it's just probably a couple minutes each, is with that in mind, there is a foundation to using this language and these rights. I don't think any statutory authority in the UK can say that they're ignorant of what the content of those things are, right? But there is a limit to actually how effectively we're using them. So specifically as people who work in devolved authorities, so just leveraging your particular experience, what can civil society do to use the ECHR to advocate for protection of our rights? Or just in this context, like today, this year, or if you want to have a go at Abby's question from the chat, what could or should we do to get more people, the question is, interested in the ECHR? So most people who are concerned about it are activists and are very knowledgeable, but actually we haven't fully engaged the public or people who need to know in this. So it's your choice of question. What should civil society advocates do? Or what should, I guess, vis-a-vis decision makers and statutory authorities, or what should we do vis-a-vis the public? Just a couple minutes. Can I go to Rachel first, and then I'll just let you unmute yourselves if you have anything to add in whatever.
Yeah, thank you. I think that's a really practical question. What can we actually do other than complain? And I think storytelling, to my mind, is a really, really important thing that we can all do, because imagine the number of people who are in this virtual room today and all the different stories that they have, and even stories that members of the public would have that would be human rights-based stories. And I think we need to tell those stories, and most of them are very straightforward. The average member of public would have no idea that these human rights abuses are happening. They would expect that children go to school, they'd expect that they have school places, they'd expect that when a transgender child goes into school, that they are treated equally to all of the other children. And we've recently had our guidance withdrawn, and children being brought into the principal's office to explain their pronouns and things like that. And it's just horrific. A bit of a backsliding. But when you put the spotlight on the human being involved and their story, the impact on them, and the actual importance of those human rights to all of us, and even going right back to times of war, we're still in very unstable times, and to remind people why this is important and why it came about. So I think if we could gather our stories and find a way to share them in very digestible ways, using social media and things like that, we probably all have wee clips and stories and case studies and different things, and maybe we could do something about sharing that. And the other thing I think is upskilling our politicians, because politicians are generally speaking maybe not au fait in the language of human rights, or people feel it's an airy-fairy topic, or it's complicated, or I don't understand it. So if they have the tools and the support to understand how they can use it in their work and why it's important to all of their constituents, I think that would go a long way. And last point, I've recently had the pleasure of being at a teaching conference, speaking to loads of senior teachers, and the theme of my talk to them was that they are human rights defenders. And I think they love that notion, that they could actually have an effect on children's human rights and help children to defend their own human rights and be advocates and be powerful, have a power, as opposed to worrying about, oh, we don't have resources. So it's empowerment and building knowledge and awareness.
Thank you so much, Rachel. And Tim or Rhian, I invite you to pick up the baton.
So maybe a couple of additional things on top of what Rachel has said. I think in terms of politicians, my feeling is, I mean, we have in the Scottish Parliament the Equality, Human Rights and Civil Justice Committee. I was pretty dubious when civil justice was added into their remit in this term of the Parliament, because equality and human rights is plenty big enough subject for a committee to cover. But I have a feeling that the focus is more on equality and equality law, even though that's not devolved, than it is on human rights. And I think in Scotland, to some extent, and maybe it's true in England and Wales as well, we have the opposite problem to the one in Northern Ireland, where your equality law in Northern Ireland is very piecemeal. So human rights is perhaps, as Kevin was saying earlier, more important. Whereas here the focus tends to be on equality law, and the obvious example there is the mess that we've got into at the moment, thanks to the For Women Scotland versus Scottish Ministers case at the Supreme Court earlier this year, where the Supreme Court put a lot of effort into the detail of exactly what they thought equality law meant. And if you read their judgment, human rights is hardly mentioned at all. So getting that balance and the focus there on human rights is one thing. And then the other thing, in terms of the public, I think the fact that human rights are for everybody is important. And I didn't have time to mention another case actually related to civil partnership, which happened in 2018, where a mixed sex couple took the UK government to court because they weren't allowed to register a civil partnership, because then it was only for same-sex couples. And they won, again, under Article 8 together with Article 14. And since then, thousands of people every year, thousands of mixed-sex couples have been registering civil partnerships. So that's a case where sexual orientation discrimination has benefited people who are not LGBT. So making it clear, I think, that human rights are for everybody is really important.
I'd certainly support both my colleagues' comments, and add, I think consistently using the language of rights is really vital. That's something that it's been really important in the disabled people's movement, because the language has often been around charity, around welfare, around medicalisation, rather than a social model approach, which is looking at how barriers in society and lack of rights, poverty, that is what marginalises disabled people. And it's about how people have a voice. Rights are about how people have a voice. People should be part of decisions. It's the kind of nothing about us without us. People do need to be engaged about and involved in decisions, either about their lives as individuals or broader policy, areas. And certainly in Wales, that's been important to us, campaigning with the Senedd and Welsh Government about disabled people having those rights. Recently, or early in the summer, the Welsh Government published its Disabled People's Rights Plan, which we're hoping will be published before Christmas. And they sort of align with the UNCRDP social model of disability, and I think it's kind of that progressive approach, which is about taking society forward, not holding people back, enabling everybody to have the right to flourish and be, live their life, really. That's what all of us want to do, and I think the rights are there to enable us to do that.
Thank you so much to my panelists. I'm just going to recap a little bit and also read some comments for the chat before I let you go. So varied responses from Centre the people and the stories. And I see from the chat as well, Paul from the Sold Network, who I think practices in Scotland, has also said educating using actual stories and real life examples demonstrate that human rights belong to everyone, which is like very firmly echoed, but also pointing out that media like film, social media, reels, easy read are all kind of ways in which we need to think about communicating better. I think we probably all knew that, but whether we've made real progress, is another question. So that very much echoes what Rachel said. To Tim's point about, because I'd asked about leveraging the ECHR specifically in devolved areas, looking for opportunities, like in Scottish Parliament, to keep the focus on human rights as well as Equalities Act legislation. So we have more than two sets of legal frameworks. And actually, sometimes it's human rights that for some places and for some people is going to provide greater protection. So that's something we can all do on a local, regional, national level. And that leads really nicely to Rianne's point, both about continuing to center lived and living experience, but doing that in a very practical way, like again, getting local, regional, national governments, right, to sign up to process commitments. So human rights-based approaches, I guess, to use that language, right, like actually for accountability and for making policy that will maybe outweather or outlast any, shall we say, national or global uncertainty about the legal frameworks. I hope I've done you justice. I also want to thank you again for coming on to this panel, and I'm now going to speed you on your way, but I think maybe if there's sort of 10 minutes at the end, we might invite everyone who's speaking back up just for final questions, or maybe I like to give people one final pass, that kind of, is there anything else moment. So thank you very much for now, and then we'll hopefully bring you back just before the 2 o'clock hour. So that leads to the last panel for today, which is, as I'm told, an interview with my former colleague, Andy Cyril. Hi, Andy. And just 1 second. Well, let's see if I can find something under the desk. Here we go. Okay, so I can't find my whole thing. See, I wanted to do a little little microphone.
I have a water bottle here, Jen. I can do that.
There you go. So for the final session for today, this is called Debunking the ECHR and Current Debates with Andy Cyril from Just Right Scotland. Just for those of you who don't know Andy, Andy is co-founding partner and legal director of Just Right Scotland, where I also worked. He heads the Scottish Refugee and Migrant Centre. And before you possibly came on, Andy, I said that one of the things that you might have to say about today is maybe a little bit insight in terms of the announcement that we had last night around immigration and asylum. I'm sure everyone's interested. He sits in the Law Society of Scotland's Immigration and Asylum Committee, as well as the Scottish Government's Child Trafficking Strategy Group. Previously, showing your commitment to the ECHR, Andy worked as legal officer at the Council of Europe in Strasbourg, supervising the implementation of British, Irish, and Cypriot judgments from the from the European Court of Human Rights. He's also taught European human rights law at the University of Glasgow for over 7 years. And so how Andy and I thought we would run this session, and that's why I'm so excited with my little fake microphone, is that I would ask him the kind of hard-hitting questions that human rights lawyers get asked in the press, and I would leave him to respond, because this is about current debates in the ECHR, and as I think we've just highlighted, it's really important how people hear about human rights, but specifically European Convention rights in the press. So, Andy, as legal director of JRS and an expert on the ECHR, the audience will know that you're signed up to the concept of the European human rights legal system.
Mm-hmm.
But both the previous and the current UK governments have said that the European Convention constrains their democratic authority to do things like control our borders or keep people safe. Is that true? Have we gone too far with the ECHR?
Thanks, Jen, for that softball question. The answer is no. It does not constrain governments from keeping us safe. But yes, it does constrain governments. But that's the point, right? So it stops governments doing illegal things, or it helps us obtain accountability for when they do illegal things, and they do illegal things a lot. So obviously, with respect to immigration, that has been used as the justification for what is a fairly full frontal assault on the ECHR and what it means in our sort of constitutional framework. The irony being that by focusing on asylum, the main international legal instrument behind that is the Refugee Convention 1951, not the ECHR. However, if you ever needed evidence that this is politically motivated, then here we are. I suppose, you know, if we break down a couple of things that the government said yesterday that they are attempting to do. The first one is they are attempting to dilute Article 8, the right to respect for family life, private life, home correspondence, etc. In this context, we're talking about family life. And they're going to do that, or they're proposing to do that in 3 ways. The first one is where a person says, please don't, or please can I stay in the UK because I've got family members here. The government are saying, well, we want to really prioritise public interest, and we're going to do that even more so than we are already. My sort of, I suppose, point that I would make about that is that's already the case, right? Public interest is already taken into account. It has to be taken into account. It is taken into account in the courts. So they're sort of stating something that's already happening. The second thing they're saying, and this is really concerning, because you can see this spreading across different areas of law as well, is that family members, insofar as they get protection under Article 8, are only your immediate family members. Your spouse, your kids, maybe your mum and dad. No one really beyond that. And that is deeply concerning, I would say. However, they do have a sort of escape clause in it that says, unless you've got an exceptionally close family relationship. Point number 2, which is the same as point number 1, that is already the case in law. And then the final point is that they are attempting to determine that family life is not unitary. What do I mean by that? It means that family life only applies to the person who's asking for it, not the rest of your family members. Give you an example. I was recently in court for a Palestinian case, a refugee who lives in the UK. She was seeking reunification with her siblings who were displaced from Gaza. The Home Office were running an argument that said, you, the judge, cannot take into account anything that has happened in Gaza. You cannot take into account anything that happens in Egypt. Their lifestyle, their precarity, their destitution, their trauma is completely irrelevant as to whether they have a family life with their sister in the UK on whom they are entirely dependent. And that is a sort of, that's the line of argument that they're looking to take. The second thing they're looking to do with respect to weakening the ECHR is relating to Article 3. Now, we've spoken about Article 3 already, in human degrading and ill treatment and torture. The line that they're seeking to take here is, if you have committed a crime, we would like to send you back to experience inhuman and degrading treatment because you've committed a crime, and actually it doesn't matter that you will be experiencing inhuman degrading treatment. Now, they acknowledge that they have a problem with that. Their line is that inhuman and degrading treatment is now, the threshold for that is too low. They say Strasbourg's gone too far, it's lowered the threshold. Now, I'm not sure that's the case, and we have lots of case law over the years, some of which was mentioned by Kevin earlier, which tells us what torture is, which tells us what inhuman degrading treatment is. I don't think the case that we're now just talking about any kind of vague risk is right. But what's really crazy here is that, or what's really concerning, I should say, is that they're attempting to make Article 3 not absolute anymore. So they're attempting to give circumstances where experiencing Article 3 treatment is okay. And that is a big deal. It's also, the line, the reality is that they can't just sort of suspend Article 3. So what they've acknowledged is that they need to speak to other countries in Europe and convince the Council of Europe to accept that Article 3 shouldn't be absolute anymore. Can they do that? Maybe. I don't know. We'll have to wait and see. But here's the point drawing all that together. When you dilute the rights of one group, you're diluting the rights of others. Once they're telling migrants, no, your brother is not your family member and doesn't get Article 8 protection, that same argument will be run in care settings for children. It will still be run in adoption. It will still be run in all sorts of other areas. And that's something we need to guard against.
Thank you, Andy, for that analysis. And I see people nodding nodding their heads to the point that the problem with diluting rights in one area or for one group of people are if we tolerate that can and will lead to dilution in other areas. I think it links back to the previous point about how all of these articles are interpreted through law across a series of range of circumstances. So actually the way that this works sort of invites that to happen. But I wanted to come back to that point that you made, because that was really interesting about Article 3 and you know the I would say we're still at the stage of flying it up the flagpole, but the proposal that if you've committed a crime, that the Home Office thinks that they should have the right to return you to another place where you might face Article 3 breaches or cruel, inhumane, and degrading treatment.
Mm.
And it's this, and I think this is for all of us to ponder, thinking about, you know, disability, LGBT identity, you know, experiences of racism. It is states that determine whether or not we have committed crimes. And actually, there's wide variation in what is criminalized or what is criminal across countries and even within countries historically. And so what's disturbing is that perhaps in the press, when we say, well, you know, we'll send, you know, foreign national criminals or people who've committed particularly serious crimes to this particular fate because we're willing to chip away at the idea that everyone deserves the same standard of protection. What you invite is again this dangerous, you know, power in the hands of states to then determine what other groups of people through criminalization, right, could have their rights eroded. I kind of just wanted to pull that out. It's a bit of a kind of like, you know, law school seminar point, but it's actually very real in this case. Like I invite people to just think about everything you've heard, both from Kevin Hanratty at the start, right, about the inability of the state to uphold safe standards for everyone and the power of the state to declare some people criminal, right through to what Tim said in the middle about campaigning against criminalization of identities and behaviors, to what you just said, Andy, about yesterday's announcement, which is framed in the context of rules that will only apply to a marginalized group, that is migrants, I guess, in the UK. But if allowed to pass, will be a useful lever for reducing rights for other groups. Sorry, that was a bit of a lecture, but just thought it was just a response to what you said. So Andy, we're invited to take at least 5 more minutes in your session, and if it's okay, I have one more hard-hitting question. It is also again focusing today on the ECHR and devolved authorities, or at least what the ECHR is to the UK. So tackle this how you wish. So I accept your position that the human rights guaranteed by the ECHR are somehow essential to all of us or important for all of us, although you took that piece in the context of, you know, migrant rights today. But do we need this particular instrument in particular? So do we need the European Convention on Human Rights, or specifically, does the UK government require to continue to be a member state of the European Council? Or could we accomplish all of this with a British Bill of Rights, something that the Labour government, the Conservative government, and we have yet to see whether the current Labour government have been very taken with, a Britishness Bill of Rights, or for that matter, because people on the call have heard this as well, in Scotland, a Scottish Human Rights Act, or in Wales, the Welsh devolved approach, or in Northern Ireland, should they have the powers to do so, a specifically different Northern Ireland approach. All of the human rights consortiums have advocated for different frameworks. So over to you, Andy. Do we need the ECHR?
Okay, so short answer is yes. But I'll pull out the downside of going down solely domestic law territory and the upside of what has been proposed in some of the devolved administrations. So the answer to that question is basically, do we want a standalone piece of domestic law, or do we want something that incorporates an international treaty? And when I say incorporates an international treaty, I mean it pulls it down from the international level down into the domestic level. What's the difference between the two? The best example I can give you about a piece of domestic law that would be that sort of emphasizes the fragility of that approach is with respect to the UK government and the Supreme Court sort of standoff about Rwanda. So about 18 months ago, the Supreme Court said, on the facts and on the evidence, Rwanda is not a safe country to send folks seeking asylum. And then the UK government, UK Parliament, I should say, passed a piece of legislation that said Rwanda is a safe country. There was no factual change. It was just the UK Parliament passing a law that said black is white. The reality is no longer reality, and they can do it. They have the power to do it, right? That emphasizes the fragility of domestic law. Any replacement to the ECHR, and so when I'm talking about the ECHR in the domestic context, I'm talking about the Human Rights Act. Any replacement to the Human Rights Act would almost definitely be weaker. You're going to break the connection with Strasbourg. And the connection with Strasbourg is really, really important because it gives us as citizens an extra layer of protection against the Parliament, the Black is White Act 2025. It gives us an extra layer of protection against that. It guarantees that we are tethered to European progress because the Strasbourg case law is a living instrument and it adapts as values go along. To Tim's very interesting talk there, the successful cases, for example, in LGBT justice, have come off the back of unsuccessful cases. So when we're thinking about adoption for same-sex couples, for example, the case that guaranteed that in European law was called EB in France. But 8 years before, there was a case called Frete in France, which failed. But in that period of time, it moved the case law along. So having the HRA keeping us tethered to the ECHR means that we move with European progress. If we did not have the HRA and the ECHR, we would not have incorporated the ECHR into our law anymore. Now, the elephant in the room with international law is that it's not enforceable. States can do what they like, unless you have a court by which you have to abide by the judgments. And that's what we have as people who live in the UK. And this is really important. Like, loads of examples have been given already. ABC against Ireland was about abortion in Ireland and forced the Irish government to confront the Republic of Ireland government to confront access to abortion. Kevin's run through cases like McCann to do with the so-called Troubles. You know, when I used to work in Strasbourg, a big case of mine was called Essen Marper against the UK, and that was about the UK government storing all of our DNA and putting limits around that. You know, there are loads and loads of examples. States typically don't like accountability. That's why they want to get rid of it. But we cannot let them do that. Now, on that point then of the Scottish and more devolved administrations, what's so important about the proposals for those human rights bills is that they are still incorporating that European treaty. They're still pursuing that model. They absolutely have to. If they don't do that, they will not have the strength that they need to have. So, for example, the Scottish Human Rights Bill incorporates UN treaties on race, gender, disability, economic and social, cultural rights. It allows organisations, some of those are on the call today, to take cases on behalf of the people they represent. So you don't have to put a victim through an awful long and traumatic process. So we don't need to have heroes like Jeff Dudgeon. We can have hero organizations doing the lifting instead. That's really, really important. But I can't think of any greater challenges in our time than issues like race, disability, gender, and economic and social cultural rights, particularly when so many violations and so much injustice in the United Kingdom. And this is not unique to the United Kingdom, but it's particularly prevalent in the United Kingdom, is born out of class and poverty. That's where so many of these systemic issues come from. So if we can pass legislation that incorporates ways to try and stop that, then I think we're all better off. So I suppose my final view is would be, well, let's have both. Let's have the ECHR and those additional things.
Thank you so much, Andy, for that really informative, again, educative roundup, and also Yeah, I'm on board with both. What I'm going to do now is invite the previous speakers who are still here into the room, if we can maybe pin everybody. And you're welcome to ask them questions, but I'm a wee bit aware of our time. But what I thought I would do is kind of take the question, the chat box question at the start, and ask that of you. And this is you kind of get like, 1 minute each. This is your chance to either answer that chat box question, which I'll read out to you, or if you're the kind of person who has to have the last word and you're like, actually, I heard something from someone else and I want to say this instead, then you can jimmy that in as well as answer the question, because I know what you're all like. So the question is, what are some of the ways that we should work together, or things we should or could do to protect our ECHR, which is remembering that this entire event, this incredible event, was brought to you by the Human Rights Consortia, is very much what the Human Rights Consortia are about. They are about drawing civil society together to work to protect our human rights, and also working across the devolved authorities. So the question is, what is, maybe just because it's 1 minute, what is one thing that you want people to do to protect our ECHR? And if you wish, you can have a quick canter at a closing thought. If we just go around, then I'll bring us to a close. So if we maybe just start from in the order we went, so maybe Charlie, Kevin, Ellie, and then Rachel, Tim, Brianne, and Andy. Is that okay with everyone? Yeah, so over to you, Charlie.
So communications, I think a lot of that has been covered already, and people actually arming themselves with the information about why the ECHR matters to them. I think that's fundamental. There's a lot of work ongoing at the moment in working out shared lines and information that we can take. And I think the three consortia will be really, really keen to drive that forward.
Yeah, I would agree with that. I think sharing information and those success stories is really, really important. I think if you're not a member of a consortium as an organization, please join your local consortium, which would be really important. I think it's just, my thought would be, it's important to remember that we've more in common than divides us, not just as consortia or NGOs, but as society. And I think the tactics around this, it's essentially aimed at dividing people, about creating false narratives, about creating division where it doesn't exist, and detracting from, as Andy said, some of those sort of class politics or issues around social and economic rights or poverty, that we should really be focusing on. So I think from a communication perspective, it's remembering that we have more in common, and that we shouldn't allow politicians to divide us like this.
And unsurprisingly, I would agree with my colleagues. I would add to that. I think if you're here or you're already engaged, talk to other organizations that work in relation to rights but don't know its rights, because they think about it as equalities or a different issue or health, and get them in touch, get them to say, can you educate us? And we, as consortia and other organizations here, I'm sure we have loads of resources. We can share loads of information. So getting more people involved who don't realize that they are working on rights, but they don't know they are rights, really would help strengthen our case even further.
I think I'm next. Yeah, I agree with all of that, and reflecting back on it, I think there's strength in numbers, and whatever we do, we should do it together and employ other groups of people that are large and strong in number, such as, for example, teaching unions, which captures thousands of teachers who have access to all of the children in our schools. Social workers, doctors, all of these professions that actually would have an understanding of what it's like for vulnerable people if their rights aren't met. And try and unify the voices, and give ourselves a bit of power in making our arguments. And the other thing I think is really important is that we give voices to affected people. And of course, in my work, I'm thinking about children. We've currently started a podcast called Rights Unmuted. I think there are 2 episodes out, and there's an education one coming soon and a mental health one to follow. And in that, we have young people asking the questions of decision makers. And I think it's really important to think, if we're communicating messages out, that some of that communication comes from those with lived experience.
Yes, not surprisingly, I agree with what's been said. And I also think it's important that we widen our communication to society as a whole, because all of us here probably are quite keen on the idea of human rights and perhaps have some understanding of it. But many people don't either of those things. And we've got to get that message out there from people's own experience of why human rights is important to everybody.
Yeah, I think in total agreement here. I mean, I think we need to be calling for strengthening rights, human rights. I think there is so much disillusionment and disenchantment in society with our, political leaders, and that in itself creates division. So I think actually how we strengthen our rights, and and also celebrate success as well. Just thinking about the disabled people's rights movement, we had a real battle on our hands over the summer around the benefits bill, but we joined forces, we worked together, we shared resources, we did we threw everything at it, and we're not out of the woods yet by any means, but I think it does show the power of the people. And that's so important to hold on to.
My last, Jen. Yeah, I think everyone's been. Yeah. I have a friend of mine who is French, and he said to me, I'll always forget this. He said to me one day, Andy, I get the feeling that where you live, the people are afraid of the government, but where I live, the government is afraid of the people. And that has always stuck with me and is probably very, very true, especially in France. But yeah, I think that, and when I say the people, I don't mean a sort of tiny little loud loud minority. I mean the sort of people power that Rianne was just referencing there with her sort of her sector's success in the summertime there. Yeah, I agree with what everybody has said. From a legal perspective, we need to be helping campaigns and campaigners, probably not leading them, because communication is best left to other people with less jargon. Yeah, and reminding people that even though you might not think you're working in human rights or defending human rights, many times you actually are. And the candidates that I think of most clearly in that circumstance are like social workers. Yeah, I'll stop there. Thanks, Jen.
Thank you so much, Andy. And I maybe just have 1 minute to wrap up, and I will do it in the 1 minute. So first of all, a very big thank you to all of our panelists today. You're brilliant. And I just loved this so much. I loved spending my Tuesday lunch with you. And to the Human Rights Consortiums in Scotland, Northern Ireland, and Cymru for organizing this incredible event. In closing, I said that we're here today because human rights are at the forefront of what we are seeing today, and we're here to celebrate the 75th anniversary of the European Convention and the establishment of rights that in theory can be exercised by any of us in the experience that our humanity alone makes us deserving of safety, protection, dignity, and respect. All of us are children of that legacy, and we've made our lives in the shadow of that protection that the legal instruments afford us, whether or not we know it and whether or not the public knows it. That's how we grew up. Whether it's visible to you or not, these protections keep you safe. They keep you warm. They feed and clothe you. They keep the lights on. And if you doubt that, ask yourself why what happens in Gaza, in Sudan, in Ukraine, and to undocumented migrants across Europe, including here in the UK. Ask yourself why that happens to them. One part of the answer is that they are not recognized as having the justiciable rights against states. Maybe sometimes they're intentionally excluded from those rights. So today, with a stellar panel of human rights experts, practitioners, and activists that you've heard from, you have heard about what safeguarding rights in devolved nations looks like, what we need to do in practice, and you've heard us debunk some of the myths about the European Convention. I hope you find this a useful use of your time. I know I certainly have. And before we go, we have one ask of you. I think I said at the start, never more needed, and the panel has told you what you need to do. The ask is this: law is a living instrument. It needs to be made and remade. It needs to be encouraged, and it needs to be protected. Law is an empty vessel. So it matters who holds it. It matters what is the substance it contains. and people like you are changing that. It matters who pours out justice, right? These matters are in your hands, and they are in our hands. So please take what you learned today and do what you think is right with that knowledge. And I'll end, because I love Eleanor Roosevelt, with a thought about the Universal Declaration on Human Rights. Eleanor reminded us that it isn't enough to talk about peace, that one must believe in it. And it isn't enough to believe in it, one must work at it. But she tells us that the future belongs to those who believe in the beauty of their dreams. Thank you very much, everyone, for coming today. Have a lovely day, and I'm sure the consortiums will circulate the details to you afterwards. Thank you.